Question arises, can the Supreme Court amend the US Constitution? Of course, the obvious answer to this question is that it cannot. Only Congress and the states can formally amend the US Constitution, as seen in the slide. The amendment process was all carefully written down in the original Constitution in Article 5. Constitutional amendments can be proposed by either House of Congress or by indeed a National Constitutional Convention. In the former process, Congress must propose a constitutional amendment by a 2/3 majority in both houses of Congress. In fact, the President plays no part in this. In the latter process, which has never been used, a National Constitutional Convention can be called by at least 2/3 of the states, and they would propose an amendment. Congress has successfully proposed constitutional amendments on 33 occasions since 1787. Once proposed, the amendment must then be ratified. Again, there are two processes, either by state legislatures or by state constitutional conventions. In the former process, 3/4 of the states must hold a constitutional convention and vote to ratify. This has been used successfully for just one amendment, the 21st Amendment, which repealed the 18th Amendment, thus ending the constitutional ban on alcohol. Thus, there have been 27 successful amendments or attempts to amend the US Constitution, and none of them involved the US Supreme Court. But what we have just explained is the formal process of constitutional amendment, the changing of the words. What the question asked in this chapter alludes to is what might be described as the informal process of constitutional amendment, the changing of the meaning of the words. Former Chief Justice Charles Evans Hughes famously remarked that Americans are under a constitution, but the constitution is what the judges say it is. By this, Chief Justice Hughes was referring to a consequence of the court's power of judicial review, the power to declare acts of Congress or of state legislatures or actions of the federal or state executives unconstitutional. In declaring legislation or actions unconstitutional, the Supreme Court is in effect telling us what the Constitution means today. What phrases within the Constitution, mostly written in the 18th century, mean today in the 21st century. Originalism versus the living Constitution. Before we get to answer the question, we need to say something about the two views which exist on what the role of the Supreme Court should be when deciding such cases. We have so far referred to justices as being either strict constructionist or conservative, or loose constructionist or liberal. But there's another pair of terms we can use which are particularly relevant to the debate concerning the role of the Supreme Court in amending the Constitution. Originalists on the one hand, and those who believe in a living Constitution on the other. Originalists believe that the Constitution has a meaning which is both known and fixed. It is the meaning that was intended when the article or amendment was originally written, hence the term originalists. Justice Antonin Scalia, appointed by President Reagan in 1986, considers himself an originalist. Here is Justice Scalia discussing this matter at a conference in Washington, D.C. back in March 2005. I am one of a small number of judges who are known as originalists. Our manner of interpreting the Constitution is to begin with the text and to give that text the meaning it bore when it was adopted by the people. I'm not a strict constructionist. I don't think the Constitution should be interpreted either strictly or indeed sloppily. It should be interpreted reasonably. This is such a minority position in modern academic and in modern legal circles that on occasion when I've given a talk like this, I'm asked a question from the back of the room. Justice Scalia, when did you first become an originalist? As though it is some kind of weird affliction that seizes some people. When did you first start eating human flesh? To Scalia and others like him, it is not the job of the Supreme Court to read things into or find things which are not in the Constitution. He pleads not guilty to the charge that originalists are inflexible, claiming, "My constitution is a very flexible constitution. You want a right to abortion? Create it the way all rights are created in a democracy. Pass a law. The death penalty? Pass a law. That's flexible." In other words, Justice Scalia would argue that he is not against abortion rights for women, but that reading them into the text of the Constitution that does not mention abortion rights is not the way to achieve them. It is the job of legislators to legislate, not judges. That is why Scalia and fellow Conservatives describe the courts announcing a woman's right to an abortion as legislating from the bench. Now, on the other hand, there is the other side of the debate, and here former Justice Paul Stevens, appointed to the court by President Ford back in 1975, saw things quite differently. His emphasis was on the Constitution as a living document whose interpretation should be shaped by the needs of the moment and not simply frozen in time. Anyway, argued Stevens, can one always know exactly what the framers of an article or amendment actually meant at the time? In a recent interview, Stevens referred to a 2005 Freedom of Religion First Amendment case in which the court decided about the meaning of the so-called Establishment Clause. Congress shall make no law respecting the establishment of religion. And Stevens commented, "It is our duty to interpret the First Amendment, not merely by asking what those words meant to observers at the time of the founding, but instead by deriving from the Establishment Clause's text and history the broad principles that remain valid today." It is here that we can see the great divide between originalists and those who favour a living constitution. The latter, of which Justice Stevens was an example, would argue that the Constitution gives principles that remain valid, but they must be shaped and applied to the changing realities that the Founding Fathers could not have conceived. Thus, while historical investigation can help us clarify what those principles were, it cannot, in Stevens' view, tell us how the text is to be applied today. To freeze the meaning of the Establishment Clause, for example, or any other part of the Constitution, in the understanding of those who wrote it, maybe 220 years ago, would be to put the Constitution in a straitjacket. For those who hold on to a belief in the Constitution as a living document, the role of the Supreme Court is to apply the original principles in the light of the evolving standards of decency, quote unquote, that mark a maturing society. Put more simply, the court interprets a never-changing Constitution for an ever-changing society. Because the living constitutionalists have so often held the majority opinion, certainly in recent years in the modern court, over the originalists, there are numerous examples of where the court has, as it were, amended the Constitution. Let's start with the First Amendment. One of the parts of the Constitution which is the subject of frequent interpretations by the court is the First Amendment. Congress shall make no law respecting an establishment of religion, or a prohibition of free exercise thereof, or abridging freedom of speech, or the press, or the right of the people peaceably to assembly, or to petition the government for redress of grievances. Now it all sounds very grand, but what do these phrases, written back in 1791, mean in today's America? We shall consider separately two of the freedoms addressed in that amendment: freedom of religion and freedom of speech. Freedom of religion. The opening 16 words of the First Amendment present the Supreme Court with something of a conundrum. How do you both prohibit the establishment of religion, commonly known as the Establishment Clause, while at the same time not prohibiting the free exercise thereof, commonly known as the Free Exercise Clause? It is a puzzle with which the court has grappled ever since the passage of the First Amendment in 1791. Now, for most of the 19th and early 20th century, the courts allowed a great deal of religion in public life, and especially in the schools. But more recently, in the view of many Americans, the court has been more diligent in focusing on the first of these two phrases, and less mindful of the second. Back in the early 1960s, the Supreme Court, in the case of Engel v. Vital, 1962, decided that to, quote, make no law respecting an establishment of religion, unquote, meant not allowing, for example, the New York Board of Regents, who ran the public state schools in New York, to compose a prayer for use in schools. even if students were allowed not to participate. Writing for the majority in this case, Justice Hugo Black stated, "When the power, prestige and financial support of the government is placed behind a particular religious belief, the indirect coercive pressure upon religious minorities to conform to the prevailing, officially approved religion is plain." The lone dissenter in this case, Justice Potter Stewart, accused the majority of misconstruing the meaning of the First Amendment religious clauses. His interpretation of them was this, that the Establishment Clause simply forbids the government from establishing an official church, and the Free Exercise Clause simply means that people cannot be coerced in matters of religious belief and practice. It was his understanding that the New York Board of Religions was infringing neither of these restrictions. The Engel decision brought a hostile response from religious Southern conservatives. South Carolina Democrat Mendel Rivers famously accused the court of legislating. They never adjudicate, with one eye on the Kremlin and the other on the NAACP. New York Republican Congressman Frank Becker called the decision the most tragic ruling in the history of the United States. In subsequent years, other jurisdictions tried to discover what exactly would be and would not be permitted in terms of religious observance and practice in public schools. The answer seemed to be not a lot. 2 years after the New York case, the court made another First Amendment ruling regarding religion in public schools. Abington School District versus Shemp, 1964. It was as if the court was saying, "We meant what we said." The case revolved around a Pennsylvania state law that required 10 verses of the Bible to be read at the start of each school day in the state's public schools. The court declared the law unconstitutional because it had violated the Establishment Clause of the First Amendment. The state had claimed that its practice was different from that in New York because it was not the author of what was being recited. The court regarded this as completely immaterial. And Justice Potter Stewart again offered the lone dissent. These cases set the scene for a battle that has raged within the court for the last 4 decades. In subsequent decisions, the court ruled on such matters as period of silent reflection in schools, prayer at school graduation ceremonies, Christmas displays in shopping malls, and the display of the 10 Commandments in courtrooms and public spaces. The court found that pretty much all of these fell foul of the Establishment Clause of the First Amendment. Only in one case, Zellman v. Harris,